Hello, ladies and gentlemen, welcome to Coin Lady channel. In this video, I'll be discussing some of the most recent statements made by attorney John Deaton, focusing on the possible effects on XRP following the publication of the Bill Hinman, Ethereum free pass emails and related papers, and drafts of the speech. Here's a tweet from Cointelegraph that links to a piece in which they interviewed John Deaton just today. They wrote that crypto lawyer Deaton had told them that the judge's underlying consideration of whether or not Ripple offered or sold XRP as an investment contract or XRP's standing in the secondary market in the United States might not be affected by the Hinman documents. But before I go any farther, let me clarify something. I come from no financial or legal background. Do not buy or sell anything based on anything I say or write. I am not a licensed attorney or financial advisor. For fun and as a pastime, I enjoy making videos about crypto-related topics to share on YouTube. Here is the Cointelegraph article that backs up the claim that the SEC is the wrong organization to regulate cryptocurrencies, Hinman documents. And I've been quite curious as to how John Deaton will react to this. Given that he represents roughly 76,000 XRP investors, he is, of course, a central figure in the press coverage of the SEC versus Ripple case. That's to be expected, then. I'm as interested as the next guy, but John Deaton has been less forthcoming with details. And I can only report that nothing has happened. Actually, no. I've got it covered, but he hasn't yet addressed some of the issues that you might expect him to have thought about by now. My best guess is that he's doing some serious studying today in preparation for tomorrow's live stream on his Crypto Law YouTube channel, during which he'll be joined by 3 other lawyers, one of whom is Jeremy Hogan. That's probably where everything will start to fall apart the most. However, some of the original materials remain today. Let's just dive right into the meat of this article. The long-awaited unsealing and release of the Hinman documents occurred on June 13. Bill Hinman, a former director of the Corporation Finance Division at the United States Securities and Exchange Commission, gave a major speech in 2018. The newly released documents provide light on the contents of Hinman's remarks. In his talk from 2018, Hinman argued that the largest cryptocurrency, Ether, should not be classified as a security. The Hinman files are SEC memos and emails, and they offer a complete picture of the agency's deliberations before, during, and after Hinman's speech. Cointelegraph contacted John Deaton, the originator of crypto law and a crypto lawyer, to discuss the relevance of the documents in light of their recent release. Deaton underlined in the interview that the records back up companies like Ripple and Coinbase who have been unfairly targeted by regulators. Since these records raise questions regarding the actions of regulators and the application of existing rules, they have the potential to affect legislative talks in Congress, as noted by Deaton. Yeah, so let's take a moment to appreciate that the SEC is officially known as the MUD. It is now abundantly evident that the organization is hopelessly broken. I have no idea. Here's the deal if you're still reading this. So, then, the question is, what do you do? Can anything be done to fix it? Is there any way you could repair it? The problem I have is that some individuals advocate for establishing a brand new government body to deal just with crypto. And I'm thinking, well, I guess you're not satisfied with the way things are run around here. In other words, you want more of that. You want more of a government that will act on your wishes without question. You wish to enlarge it. I just can't get behind it. Instead, I say, kick the people who need to be kicked to the curb, and tell Congress to get to work. Because of this lack of clarity, the SEC is exercising jurisdictional overreach, therefore, Congress must clarify who has authority over what. They're pros at what they do. They are obviously competent in their field. Take it to them. They're doing absolutely nothing and Congress should whack them. Like a kid sneaking a cookie from the cookie jar before supper, they shouldn't be permitted to do this. No, you can't just do that. That is not allowed. That is, in essence, how I see things at the moment. But, for the time being, My prediction is that Congress will not come up with a workable solution. Unfortunately, the only option we have at this time is to respond legally. Try getting some answers in court. In his words, the piece remains. Quote, "Hi, I'm Deaton. In two aspects, the papers match my expectations. For one, it aids the cryptocurrency exchanges Ripple and Coinbase, as well as others that have been unfairly targeted by overzealous government authorities. They swore to uphold the law. It remains to be seen how helpful it will be in the courts, but it will be useful in the court of public opinion and in Congress. 2. It brings to light the quote enormous conflicts of interest and blatant appearances of misconduct by William Hinman and Jay Clayton. Oh, that's undeniable. Former SEC chairman and American attorney Clayton will leave his position on December 23, 2020. I think a lot of people are wondering what, if anything, this means for XRP in terms of the specific impact on the ongoing legal struggle between Ripple and the SEC. Therefore, this is one of the deeper questions you may ask. Many people, I suppose, would accept that at face value. According to Deaton, the judge's determination of whether or not Ripple marketed or sold XRP as an investment contract or the status of XRP in the secondary markets in the United States is unaffected by the documents themselves. Stop quoting. Yeah. Therefore, in my opinion, that makes a great deal of sense. And that's pretty much in line with what I expected, because honestly, unless there is some sort of bombshell specifically relating to XRP, which I haven't seen uncovered, at least to this point, outside of that, I didn't necessarily assume it was going to change anything in terms of the outcome of the case. I feel like we should have been like, whoa, if there were some sort of bombshell XRP thing that would have impacted the public's opinion on a worldwide scale. However, there was nothing comparable. However, this is really significant because, as I noted in another recent video, it is making it abundantly evident that the SEC's reputation, to the extent that it was ever perceived as positive by anyone who was just oblivious, is in tatters. Now that they know, the mudslinging can continue. Ripple's claim that market confusion and participants' inability to understand what was prohibited under current restrictions were exacerbated by Hinman's statement is bolstered by these findings. Deaton also commented, the documents do assist Ripple and others in arguing that the speech caused greater confusion in the markets, causing market participants to lack adequate notice of what was prohibited under existing law. And I will say that there does appear to be some degree of unanimity, generally speaking, that among the lawyers that I have followed, since I follow a lot of lawyers in the crypto world, some especially in the XRP community, and some in the larger crypto area. What has been disclosed today, XRP aside, will be excellent for Ripple in terms of the fair notice defense, as far as the people I follow who have commented on this have said. The bad news is that something has obviously gone horribly wrong if we have reached the point in the proceedings where fair notice defenses are up for consideration. This is because it means that there were transactions of some kind that Ripple wasn't supposed to engage in. The question then becomes, was there adequate warning? This means they should not have done it, but did they have a reasonable chance of knowing this? Therefore, we must avoid arriving at that point. As John Deaton has put it before, this would be beneficial for Ripple since it serves as a sort of insurance policy. The story goes on. Deaton elaborated on the possible effects of the documents on Ether and ERC20 tokens. He speculated that the paperwork could help Ether's case by decreasing the possibility that it would be deemed a security by the SEC. Here's another one of Attorney Deaton's sayings. If the SEC ever classifies Ethereum as a security, I believe the speech records will help the case. Since ERC20 tokens like Dragon Coin are managed by the Ethereum blockchain, this might also benefit these tokens. If the SEC found the network to be sufficiently decentralized, then the tokens would have an even stronger case for fair notice than Ripple. Stop quoting. That really makes sense as well, right? Being an ERC20 token on the Ethereum network makes perfect sense for a coin like Dragon Chain that is under SEC scrutiny. Deaton said that, in light of the document's broader implications, he thinks that Congress ought to step in and provide clarity in controlling digital assets. Given the potential conflicts of interest and misconduct shown by the records, he said that the SEC might not be the ideal institution to govern the crypto industry. Another one of Deaton's quotes is included here. According to my reading of the materials, the SEC is the appropriate organization to regulate digital assets, and the records support the argument that Congress should step in and offer clarification. Yeah. To clarify what I said a few minutes earlier in this video, I am not claiming that the Securities and Exchange Commission, SEC, must be the governing body in this case. In reality, they shouldn't do so unless they have anything that is a token that is meant to fulfill the function of a security. If you think you can convince me otherwise, by all means do so. Cryptocurrencies resemble real currency or commodities in every other respect, though. Do I have to choose between the two options? Isn't that a far more reasonable explanation? Regardless, my point is that there should not be a new government organization with additional bureaucrats in charge of coming up with ideas like these. I'm sorry, but I'm just not interested. The truce holds. After being warned against giving the speech by the SEC's Office of General Counsel and the Director of Trading Markets, Hinman went ahead and gave it nonetheless, prompting Deaton to demand an investigation by the Inspector General into his decision. Hinman's description of the talk as the ether speech, as Deaton pointed out, adds fuel to the fire of speculation about the speaker's possible biases and objectives. Here is some wisdom from Deaton. According to my interpretation of the records, William Hinman's insistence on giving the speech constitutes cause for an IG investigation. The Director of Trading Markets expressed concern that the speech would cause more confusion in the market, and the Office of General Counsel advised against exempting ether. But Hinman was set on really delivering it. He referred to the address as the ether speech in his email. That's definitely a major takeaway that demonstrates William Hinman's motivation for starting this whole affair, at least in my humble opinion. Basically, it confirms our assumptions and leads you in the proper route. That he did it for his own benefit, his law firm's profit, and maybe unlawful motives. Simpson Thacher, who was interested in ETH at the time, gave a speech that focused heavily on the cryptocurrency at the time. The speech was titled Ether Speech rather than Market Clarity or Cryptocurrency Speech or anything else. Nothing like "No is Ether Speech" can get us to the decentralized future of crypto speech that we seek. All along, letting ETH off the hook was the plan. That was the plan all along. That's obvious to me at this point. We know this since the published documents have Ether Speech as the subject line. That's really ridiculous. But I think it indicates exactly what he was thinking. Do you not see how it at least suggests that? Then there was what lawyer John Deaton said. This was posted on his afternoon tweets. It's important for the public to realize that a judge may rule that XRP sales do meet all components of the Howey test, even if an SEC enforcement lawyer has previously done a Howey analysis on XRP and determined otherwise. This is a good place to pause and recall that on June 13, 2018, the day before the Ethereum Free Pass speech, an analysis was conducted. Now, that memo was a memo concerning XRP, and it has never been made public and possibly never will be. To be clear, we can say with near certainty that they did not decide XRP was a security or that Ripple was engaged in any criminal activity at the time. If such were the conclusion reached, then action would have been taken at the time of the finding, rather than the approximate 2.5 years afterwards. That much is clear. So even if it was discovered in any study by any kind of SEC enforcement lawyer, they found XRP not a security, that is not the point he is making here. You mention the possibility that the judge will rule otherwise. So, technically speaking, that doesn't imply we're safe. The SEC has already conceded that they do not have the authority to determine whether or not XRP is a security. They just accuse each other. The court system then acts as the final arbiter of truth and justice. Certainly, that's the case. In any case, as Deaton points out, that's exactly what's transpiring. Also, a judge can dispute with an enforcement attorney's determination that XRP is a security. These notes, now. Wait just a second. Note to staff. The XRP within memo. The judge's decision on whether Brad Garlinghouse or Chris Larson were reckless in not knowing XRP was being offered or sold as a security may be influenced by a finding that XRP was not a security or an inconclusive, non-public, but read by the judge XRP memo sent to the SEC arguing XRP is not a security. Even in 2018, the SEC had trouble deciding whether or not XRP qualified as a security. It's 2013, yet maybe these two executives can still be careless. As far as I can see, the answer is clearly negative. But that's exactly the purpose. That's the point that John Deaton is making. What's being said about Ripple's accusers? The degree of their success remains to be seen. When it comes to the accusations against Garlinghouse and Chris Larson, however, I have always felt that it is even more revolting. To me, it's more revolting that they're trying to intimidate Brad Garlinghouse and Chris Larson in the hopes that, because they're at the top, maybe that would have persuaded them to, capitulate back in the day. I get that there could be greater ramifications in terms of what happens specifically with Ripple and certainly secondary market transactions. Even while the SEC did make a settlement offer, Ripple rejected it because the terms were ridiculous. It was very disagreeable. That was shot down by them. In any case, that's just a bullying technique. Sadly, Ripple denied your request. And then, despite the absence of any claims of fraud, they went after Brad Garlinghouse and Chris Larson. This sort of thing would be expected if there were suspicions of fraud. The lack of fraud charges makes this extremely unusual. So now you see how low and vile the SEC staff really is, right? It has nothing to do with fairness, accuracy, investor security, or the growth of wealth. These bad actors are seizing territory under their jurisdiction and intimidating their neighbors. What a horrible species. I find them completely revolting. And you ought to be as well. This government department is just disgusting. As for whether or not it can be redeemed, I have no idea. But I will say this much. A new government with a more nuanced understanding of crypto would be a huge step forward. A new chair of the SEC can take over if desired. You can order the Congress to stop them. Consequently, if you make wholesale changes at the top, things may change. It might not be hopeless. All I know is that I despise unnecessary bureaucratic red tape. I don't. No new government department is required. The employees working in the government's new crypto agency won't be the same ones there forever, so you shouldn't expect them to have a spotless reputation. As a result, whoever takes their position will, in perpetuity, be as spotless and pristine as freshly fallen snow. Really, you believe that? And I know I don't feel that way. No way, no how. In any case, tomorrow will bring further commentary from attorney John Deaton. Once again, he'll be hanging out with Hogan and a few other legal heavy hitters. I'm betting on attorney Mark Fogel, who just so happens to be present. I don't always agree with him, but he seems intellectually honest from what I've seen, and I just saw on the screen that he's a former SEC attorney. As a result, I've been featuring him on my channel very often as of late. There's also this other lawyer. I can't remember his name, but he's probably Rosalind Layton's lawyer. She's been writing about the SEC Ripple case for Forbes for a while now. The last piece I saw her publish was eventually removed by Forbes. So, I'm not sure if we'll be seeing each other again. What happened, I don't know, but it happened. Those are the 4 lawyers that will be appearing on John Deaton's show tomorrow afternoon. The precise timing is now lost to my memory. I apologize. I would estimate that it is between 2 o'clock and 3 p.m. I need to verify that first. However, you should know that it will be broadcast in real time if you're interested in watching. I can't say for sure that I'll make it, but you can put your last dollar on it. If I don't catch it while it's airing, I will definitely watch it as soon as I get my hands on a copy. But, you should know, days and evenings can be hectic on occasion due to my schedule. But I really want to see it live because I'm interested in hearing what will be said and hearing attorney John Deaton's and Hogan's and everyone else's thoughts on the matter. However, that is all we have right now. I think it's time for me to end this. No, I don't give out financial advice. Nothing I say or write should be used as a basis for making financial decisions. And please like and subscribe my channel. See you in the next video. Bye.